All right, everybody, it's high noon. We're going to start our next session. Genevieve, how are you?
I'm doing great, Gary. How are you?
I'm doing great. Let me introduce Genevieve Fikes for anybody who doesn't know Genevieve. Genevieve is a great trial lawyer. I have the true privilege of working with her. Genevieve has tried the last two cases in our office. She has lately done a lot of great work and a lot of things, but lately she's really had a certain insurer's number over in Illinois. She's tried a couple of cases over in Illinois in the last, during the pandemic and after, in mass for the first time. I sat and watched you pick that jury. She's done a great job. So no BS. It's just so fun to work with Genevieve. She's meticulous, great. She's got a really winning attitude. And anyway, thanks for doing this one with me, Genevieve.
Thanks, Gary.
All right. So for this one, so this CLE is called Evidence in Closing, Admitting Evidence, Conducting Examinations at Trial, and What Not to Say in Closing. Genevieve and I started talking about this in some of her trials that she was doing, and in some of what I've seen people do things wrong, and so we thought that some of these things are hard, though. Some of these things are hard to do right. They should be straight up things like what to say in closing, how to impeach a witness. So that's the genesis of why we decided to do this. So let me just start out right away. Genevieve, did you learn how to impeach witnesses the right way, or how did you first learn how to do that, would you say?
So I remember definitely learning about it in law school, but it's different once you're practicing. And the biggest thing I think is just to be prepared and have at your fingertips the statements that you think you might need or to use. But I know that for my first trial, I was just trying to read up on all the rules that I could, but it helps to see others do it and do it yourself and hope it goes right. But this will be good advice to make sure it goes right.
Yeah, so we set it out in the material. So I'm very particular about how I impeach witnesses, because used well, it can be the most effective technique at trial. The first thing you want to do in impeaching a witness is reestablish the statement that you're about to impeach the witness on, because if not, they're going to move on you. And too many times I see lawyers don't do this. They just start handing a person a depo and saying, did you testify to this? No, first you say, did you just, and this is when you're getting up to cross, did you just testify that you were going 15 miles an hour? Were going 40 miles an hour? Did you just say the light was red? You establish the statement. You cement the witness into the position the exact way it was said. So then once you establish the inconsistent statement, then you go to the prior inconsistent statement. You identify that to the witness. Did you testify in this case on blah, blah date? At that time, did you give a deposition? Were you sworn to tell the truth at that time like you are here today? And I don't belabor the truth thing, because I think jurors get it. Some people spend 5 minutes on where you tell the truth and did you sign the deposition and stuff. I think people get it, so I don't really do that. Here's your deposition transcript. Could you turn to, this deposition was taken on blah, blah date. Do you recall that? Yeah. Did I take that deposition? Yes, I did. Or did Genevieve or someone else? Yes, I did. Can you turn to page 42, line 12, whatever it is? And you say, did I ask you how fast were you going at the time of the answer? At the time of the impact? And what was your answer? And then you get them to say that. You have just impeached them. You're done. You're done. You don't need to jump up and down. You don't need to do that. You are done. And then you ask the next question. And when I cross-examine a witness, I'm a little persnickety about it. I have the questions written out, and I have the page and line number of where they said this right next to them, or the medical record, or the police report, or whatever it is, so that when I'm crossing a witness, did you say, would you agree with me that that you were going X amount of speed? Would you agree with me? You said you were this far away from the, did you, and you agree with me that at the time of the impact, you were going 20 miles an hour? They always try to flip on that one. No, when I said that, I was going 20 miles an hour and then I slowed down and then I just dinged them. Well, listen, when I asked you that, I asked you, how fast were you going at the time of the impact? And you said 20 miles an hour. Is that correct? Yes. Page 42, line 12, whatever. And then they say yes. Or they'll say, and then the other thing is going, and in fact, that answer you just gave where you said you slowed down, we went through that in your deposition. That may give you other questions. Like, in fact, you told me you were going 30 miles an hour, 15 feet before. So that is actually not accurate. Isn't that true? Yes, I told you that. And you can take them through that. And if there's wiggle room on that stuff, you can publish the prior inconsistent statement to the jury. You have to ask the judge to do that. Do not be starting to put up a deposition. You're starting to impeach someone and having someone throw it up on a screen or put it on an Elmo. You need to ask the judge, because there may be a question or an objection later on in that page the judge does not want you to see. And just because you are impeaching a witness does not mean you get to automatically publish that to the jury. And so the reason why you're so persnickety in what your question is you want to be very clear about this. If there's a difference in your question between the words many or few or a couple, that's going to hurt you on your cross. So make sure you're clear. And it's really effective when you ask a question and then the witness dissembles and doesn't do a stuff. And a little bit later, when you read it from the transcript, it's exactly the way you had asked it for the first time. And the jury really gets a feeling that this witness is playing games. So if you look at my point 4 on our material under impeachment, I say these things. Write down the page and line number, the medical records, make sure it's right. And if you have a recalcitrant witness, make sure the first few times you impeach them, you get it exactly right. You can bell the cat, so to speak. You can curb or cabin the witness. If you go a couple times with the witness and they're playing games and you nail them on a good impeachment a couple times, they're going to agree with you for the rest of the time because they don't want to be put through that again. They're a little bit afraid of you. So if you have when you're prepping for trial, you're reading that transcript, like, I thought I asked them that, but I didn't quite ask them that way. I thought I had, but I hadn't. Save those questions for the end of your cross, because in the beginning of your cross, you want to have that nice and tight where you're cabining them, you're curbing them, they learn the lesson, you're cracking the whip through impeachment. And then they know later on they better go with you or you're going to have something, because they'll know. I've had times. You ever have a time, and there's a lot of, I see a lot of names on this list of people who are watching. There's a lot of people who have a lot of trial experience. Listen to me right now, and everybody's had this. Have you ever had it where you've impeached them a couple times, and then you got like the 4th or the 5th time, and you start to walk up with the transcript, they're like, no, I'll agree with you. That's fine, whatever you say. That's happened to us. But that means you're doing it right the first time. And if the other side is not doing it right, you can object and say that's improper impeachment. Now you have to be careful, because you don't want to do that, because it sounds like you're trying to protect a weak witness. You don't want to look like that. It's almost better to let your client handle that, because it's not important. Sometimes you're impeaching on things that aren't the essence, and if you're not the key parts of the case. And if you have the witness fighting you on that, and it's not that important, who cares? I tried a case one time, and I don't want to go to the whole story, but the client was arguing with the impeaching lawyer about whether or not she had passed a bad check. It had nothing to do with this case. So I took my pad up and I hid it from the jury, and my client looked at me like this, smile, because I had told her and prepping her and say, don't argue on cross, smile and say okay. And she immediately turned, she looked at the client, she said, you're right, I passed that bad check. They went on, the jury didn't care. But if she fights about it, they hate it worse. Don't overdo using the transcript or prior statements. Use only when it is truly inconsistent, because then you look like you're trying to be mean. Remember, don't talk loud. you remember people visual. Don't be yelling at a person about, you said this then. You just lay it out there nice and easy, because they'll visually see that and think you're bullying the witness, especially these days. You got to be careful about that. If the witness won't answer the question, if they won't read from it, you read from it, and then you publicize it, because they don't want, oh, you want me to read this? Yes. Oh, you want me to read the whole thing? No. Well, hold on, they say, hold on, wait. No, I don't want you to read the whole thing. I'm sorry. Did it, and then you hold it, and I pick it up, hold it in front of the jury. The box is right there, the witness is there. Didn't I ask you, how fast were you going? And isn't your answer 40 miles per hour? Isn't that correct on that line? Right. You didn't say anything else in that answer, did you? No, I didn't. Okay. You can jump around in the transcript. You don't have to go in order. In fact, it's more effective if you don't. It's more effective if you don't. If you can do, you do a question on page 12, and the next question you have is on page 42 and then 56. You don't need to go in the order of your depo. And sometimes it's more effective if you're jumping around, because then they're moving. Hey, I just see Laura Lumagi. Laura, how are you? Great to see your question. She asked a question. What about, well, she asked it to me. Hold on, that's a direct message to me. Sorry to call you out, Laura. I didn't know that was.
No, you're good. You're good. I'm sure everyone has the same problem. So
thank you. What about if the witness says, oh, I don't remember, I don't recall. So if they didn't remember anything, well, you don't have anything to, well, here's how you, so let's say you take a deposition and the person is saying, I don't know all the time. And then you're sitting there at trial. Well, if then the only way to impeach them, Laura, at that time is all of a sudden they remember everything at trial. And then your impeaching is to say, you didn't remember any of this in my deposition. And I took this deposition 1.5 years ago. Wasn't that close to the time of the incident? Why on earth, when we did all this work, and remember in my opening statement, I said all the work we did to bring this case to the jury because it was important. Well, how come you never told me this before? How come you never put it in your answer? And now you have all the answers in this trial. It makes them look like they're playing games and hiding the ball. And you can show it to them, how many I don't knows there was. And the other thing is, I do this, I say this in material, Laura and everybody else, is I often, when a lot of people in the beginning of a depo have this long speech. My only things I ask in the beginning of a deposition are, I want to make sure you understand my question. If you answer my question, we're all going to assume you understood it. And they say yes. And then I say a couple more. I say, and listen, this is really important, because we're doing this deposition by Zoom. You really need to know this. I'm trying to get to the truth here. I'm trying to get this. So I don't want to have any misunderstanding. Yeah, okay, cool. And then they think you're going to leave it, and then you don't. And then I say, and I've read this to juries before from a transcript. I've said, because at trial, I don't want to be asking you questions and then you saying that in this deposition you didn't understand what I said. And that really, it can be effective later on in a trial. So I'm going to move on. If you have the person who, but remember that if on the stand at trial they don't remember, but they remembered in their deposition, then you're refreshing recollection. You're not impeaching, you're refreshing recollection. Okay, you don't remember? Here, let me show you. I told you this, you said 40 miles an hour, boom. And then you refresh it. And then you say, now do you remember? You were closer in time, blah, 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 blah. Are you changing? So then you refresh your recollection. They say, oh, okay, that's fine. And then there you go. I think I'm hitting all the points. I talked about the opening statement. Remember that you're not just impeaching from a deposition. What about a police report? It's important to use that police report in that deposition to say the officer said this, this, and this, and get them to adopt or disavow what they're going to say. You may need to call the cop. You may need to call the officer. Did they tell you this? They wouldn't tell you this if it wasn't true. You wouldn't write it down if it was true. Remember, with a cop's deposition, an officer's, I don't want to say cop, police officer's deposition, you need to make sure that it doesn't need to be the exact words. They communicated this to you, regardless of what was said, what was communicated to you. You thought it was communicated to you that you whatever it is that no, you didn't tell anybody that there was a sudden stop in front of you, or other traffic was slowing, or all the other stuff. Remember that officers get stuff wrong in police reports all the time. It just happens, okay? So you need to establish others, and it happens in medical records too. So you need to establish that also. You know, I do this podcast with Debbie Champion, and she and I talked about this on a podcast. And on the defense side, what she does is she uses these statements from medical records. And it doesn't matter whether or not the nurse got the pain was a 4 out of 10 or an 8 out of 10. She uses this and she pulls up these medical records as prior statements. It's up to you to, if you want to combat that, you need to work on that with your client, and just don't argue about it. The record says what it says. Don't argue about that. And then you find, I've had this many times too, is they'll cherry pick the 4 out of 10 on the pain, even though the next PT visit was an 8 out of 10. And so then your client says yes, 4 out of 10s, and then you come up and show the next PT record and showing how it was an 8 out of 10. And don't argue with it, but you just show that, and and then you prove to the jury in that way that the lawyer was creating a false record to the jury and cherry picking stuff that was good for them. Let me move on to the next topic. Using statements and medical records to cross-examine or impeach a witness. That's what I was just doing. I think I was talking about this. So you use this to show that the witness is inconsistent. How can this person be saying there was all this pain when the records from the PT visit say this, that, or the other thing? And you need to do your work on that. You need to depose the PT person or the doctor, or really get to why this is happening, because complaints of pain can really vary. And people like to be, so if someone be real with their medical provider. So if someone can do a lot of PT, they can walk in saying it's a 3 out of 10. Then they go through PT and work hard, and then they're on the couch for 2 days. You need to establish that too. And you need to be talking with your client while they're treating to say, don't walk in there and say 2 out of 10 every time. You're going to kill us. You need to come in and you need to say it was a 2 out of 10, and then tell the PT person they're having problem. You can't do this. And now it's a 5 out of 10. And you also need to say when you direct examine them, you want to take the wind out of Debbie Champion Sales and all the other great defense lawyers that may be on this thing, is you take the wind out of their sails. Hey, when you went to the doctor, did you have good days and bad days? Yeah. Did your pain wax and wane? Yeah. Describe it to me. Yeah. So if we look in the medical records, we're going to find some days that it's a 2 and some days that it's 7, right? Yeah. Let me show you some examples. You show a 2, you show a 7, you show some different stuff. You take through the whole context of the record and how they are now, and then you take the wind out of the sails of the defense lawyer. And then, move on though, make your points on these crosses and move on. So even when you're using statements and medical records to cross-examine, don't belabor it, just go with it. And then if you're redirecting, if your client is hit on hard on cross and you get up and redirect, you show those other medical records and you do that stuff too. So my next section is, and I want to get to Genevieve's stuff too. Genevieve's going to lead more. Genevieve, am I missing anything what I'm doing so far?
I was just going to add something, that it doesn't matter how good of a lawyer you are, you have to be prepared and you have to know your case. Because if you aren't familiar with the testimony and the depositions, then you won't realize when there is an inconsistent statement. So you really want to logistically do a deposition index where you know what the main admissions are or what might come up. And then you want to print out extra copies of these transcripts so that you have them, and do that ahead of time. So it's not, Sunday in the office before trial and the printer's broken and you have to print out these transcripts. Like, just do that ahead of time. So I guess I would just add, be really prepared so that it goes smoothly and will be more effective.
Great points. And I remember, when you're impeaching with that transcript, one copy is going to go to the witness, one copy is going to go to defense counsel, and one copy is, you need at least 3 copies. Sometimes you need a copy for the judge. So I always say original and 3. And then on my copy that I have highlighted and tabbed, and I have these ripped up yellow Post-its all over them. I put my initials on the front and I highlight mine. So I know which one is mine. And while the witness is testifying, I'm not just sitting here, just daydreaming. I am going through and finding where they are, and I'm putting new Post-its on the top. I have my Post-its on the side But then when I have good stuff that I find out right there, I put the Post-its on the top of the stuff I want to hit so I can see them. Because when I stand up and cross and I'm trying to be smooth and stuff, I don't want to be fumbling, and I want it to jump on me because I'll forget stuff. And I make a lot of notes, but I circle the stuff that I want to do. And then and then when they're directing, I put a line on my paper like this. And then and my notes are over here, but the stuff I want to cross, I have a separate column for what I want to cross on. That's what that old legal line paper where it used to be lined like that. The old lawyers like Clem Burns may remember that. Hi, Clem. Sorry to pick you out, but I see you. All right, business records. Remember to get these business records into evidence. Don't assume. Remember in Missouri to have record affidavits for every business record. Remember to do your notice 7 days before trial. Remember that in Illinois, they don't have that. Remember in Illinois that you want to get a stipulation with the other side before, and if they do not stipulate to it, you're going to serve a bunch of subpoenas against a bunch of people that aren't going to be happy. And then I had a case one time where I did that. I served all the subpoenas, and then the lawyer called me up and said, all right, I'll stipulate to everything. I'm like, well, I just served all these subpoenas. So, but you got to do what you got to do. If the other side isn't gonna, that's why we try to have good relationships with the defense bar, because you want them to stick to your records and you stick to theirs. You get those agreements going into that. You get stipulations on medical bills. There's a lot of things you can curtail. And if you try cases, you want to figure out what's important and what's not. And that's not important. So, but remember to do it. Remember that just because you got a business record in doesn't mean all the records are going to come in. The police diagram very well may not come in. You may get the property damage bill in, but the judge isn't going to let you show that. You may get some medical records in, but the judge is not going to let you use the triple hearsay blah, blah, blah on the medical record. So remember that distinguishing. Remember when you're putting your medical bills in, redact, don't put in the copy with all the insurance payments. Redact what you're putting in before you put the insurance payments, so the jury doesn't have that opportunity, or the defense lawyer doesn't have an opportunity to say, hey, you admitted in evidence, I get to show the jury all that. And you're like, no, I didn't violate collateral source. All right, I have parts I'm interested. So remember, getting photos and evidence, it's pretty easy. Does this fairly and accurately depict the car wreck at issue? Yes. Remember differences in Illinois versus Missouri in what you have to produce. In Illinois, you got to produce everything. Missouri, you can hold back photos that aren't taken at the scene. But in my experience, when you're going to trial, give the photos to the other side you're going to use, even if you're a defense lawyer. Now, a defense lawyer, you may want to sandbag, and you not that way. That's pejorative. You may want to you protect your work product validly until you're ready to cross. But on the other hand, you're going to draw an objection. Why not give the pictures to the other side? I'm a big believer in not having trial by ambush. Let the other side have it. I mean, do you think it's going to that materially affect things? Probably not. Remember, don't just use. Prep your witnesses to identify the photographs. You don't want to have your client on the stand and have a photograph. I don't know what this is. Well, I guess that's not coming to evidence. Not that I've ever done that before. Remember, just because you get it in the evidence doesn't mean you get to publish it to the jury. Ask the judge. You go through all your wreck pictures, and then you go through all your injury pictures and say, Judge, can I publish this to the jury? Yes. No objection. You go to one end, you start passing photographs along, and they pass them around. The jury is going to notice things you did not notice in those pictures, things that are more important to them. They're going to let the jury sit there and digest them. The jury has to sit for 3 days and not do anything. This is their one chance to do something. Let it happen. Let them do it. I usually ask jurors in closing that they can ask for admitted evidence in the jury deliberation room. Sometimes judges don't like that. But I think you can, we always tell them that so that they know that, and let the judge figure out what medical goes back or what demonstratives go back or not go back. Judicial notice, and then we're going to get to what to not say in closing. Judicial notice. There are certain things that a court knows are well accepted in the community, and you want to have a case in your pocket on this. If you want to get in speed or distance for braking and coming to a stop, or if you want to get in life care tables or life expectancy, You want to be able to get that. Have a case. We put the cases we have a bunch of cases in our brief here. We have some older ones, some new ones, some tried and true ones, mortality tables, judicial notice required to travel 60 feet at 50 miles per hour. Remember that the 1.5 seconds, 3/4 of a second to in reaction time to see it and react to it, and 3/4 of a second to hit the brake. That's pretty well. Most trial judges will let you do that, but have a case in case you can't. Remember, just because the other side has we mediated a case the other day, and we're going to have an expert that's going to say this, this, and this, and I'm thinking, well, they can, but I already know that I'm going to talk about stopping distance, braking speed, and there's no way. I said to the mediator, I said, there's no way that this expert's going to be able to say this, because I'm going to be able to use all this judicial notice. I'm going to point all this out to them, and they're going to have to admit a lot of stuff on that point. So just remember judicial notice. Remember too, this isn't in the materials. Remember sometimes you can't show answers or pleadings in a case. For some reason, sometimes it's easier to get abandoned pleadings into a case than real pleadings, or get a certified copy. There's weird rules about showing jury pleadings. And I don't want to get too far afield that, but if you're going to have to, let's say a defendant admits liability, and you want to show that in their answer they denied liability, in the defendant's depo they denied liability, and the only reason they're admitting liability now is to get some favor with the jury, and it's bogus. And they went 3.5 years and never admitted liability, and they're doing it today. Why are they doing that, jury? If you want to show that to the jury, you got to be ready to do it. Maybe a certified copies of things, and have a case in your pocket on that. When you're getting ready for trial for all these things, remember, you want to have a plan to get everything into evidence. You need to know the case, and you need to know how to do it, and you need to have the foundation and authenticity. Now, I would like to, Genevieve, anything else on my stuff before we turn to you're going to kind of lead the what not to say in closing part.
I think you covered it.
All right, Jen, go ahead. I love this because we've all made these mistakes, Genevieve.
Right. And we've been on both sides where sometimes your opposing counsel is making these mistakes as well. So with closing argument, you've spent a lot of time preparing for trial, trying your case. You're finally there. It's going well. The last thing you want to do is unnecessarily commit reversible error. And on the flip side, if your opponent commits reversible error, you probably want to preserve that objection or mistrial in the event that the verdict doesn't go your way. And so there's some pretty common things that we'll go through, but they are important to remember. One of the first things when it comes to damages for pain and suffering, per diem arguments are improper. And that's an argument that the jury should pay or use a mathematical formula to award damages for pain and suffering based on the amount of days that someone was injured or the amount of appointments, something like that. Now, it's fine to put up a chart and say that your client had, 300 doctor's appointments they had to go to, but you just can't instruct the jury to award damages mathematically per day or year or something along those lines.
Why not?
Because that's what the law says.
And I don't mean to be, I find that the rules against what you can't say in closing are because those are the most effective arguments. Because the per diem argument really is effective, because you say, would you get paid $100 a day to do that? First of all, you can't, I don't want to, then, and then how many days do they have left in their life? And then boom, and it's an easy way. They're very effective, but they're not fair. And so that's why I find the reason why some of these rules is because it blocks very effective things that aren't really very fair. If you ever want to know where the line is on this, and I didn't cite the case here, but Tom Strong, great legendary Missouri lawyer, took a case to the Supreme Court on per diem argument, and he rode right up to the line. I forget exactly what he did, but he's brilliant. So if you want, but I wouldn't even get close to it. You don't want to throw air into your case. You don't need to.
So then another thing that you can't do in closing argument is misstate the law. And that's the easiest way to get your case overturned or have a mistrial. So that's automatic reversible error if you misstate what the law is. You see this a lot of times when attorneys try to sort of paraphrase the burden of proof. You have to be, if you're going to talk about the law, you have to be exact with what the jury instructions are saying and be very careful. Another example that I've seen a lot are with premises liability cases where the attorney will mix up could have known or should have known. Things like that are big problems. And so on the one hand, you don't want to mislead the jury or misstate the law. But on the other hand, it's really important to also lay out the law correctly for the jury. And so a lot of times you can do that by having, printouts or blowups of the jury instructions and sort of opening up by saying the judge will instruct you that you are to do this. So those are, I think, are some of the main ones that come up.
Can I add too, Jen, that and if you're showing the instructions to the jury and you're reading those, you want to remind them in voir dire that they promised you that they would follow the instructions, and things like burden of proof and that kind of stuff. But let me ask you this, Genevieve, what do you do if your opponent quotes the law and is starting to do the law improperly in a close? What if they're crossing the line on quoting the law?
I think there's a couple different options. I mean, one, you can obviously object and, preserve that and object on this basis that they're misstating the law. Two, you can correct it when it's your turn to argue and say what the jury instructions actually say. And then third, sometimes you can get a new instruction that corrects things, a specific jury instruction that explains, what not to listen to or what the instructions should be. I think those are some of the ways.
Yeah, you got to be careful too. Should you ask for a mistrial? Let's say defense counsel gets up and starts quoting the law improperly about whether or not you called a witness or what the burden of proof is. What tack do you want to take? It's a judgment call, and I guess it depends, right? But go ahead. Sorry.
It can depend on how good your case is. I mean, if you think your case is going really well and you don't actually want a mistrial, you may not want to ask for one in case, because it might be granted. But unfortunately, you don't really know what the outcome will be. But if your case is going terribly and you don't like your jury and have a bad feel for it, then I might be more inclined to actually take it up. And I've definitely dealt with that before, where I know opposing counsel is, arguing something improper that could be grounds for mistrial, but I feel confident enough in my case that I would rather correct it another way by just explaining it myself later, rather than retry the entire case at the very end.
I had a case one time where Art Clark, and I don't mind using him. He's an effective lawyer. He quoted about why I didn't call the treating doctor, and he started to tell him what the law is, and that I get an adverse inference, and that's the law. There was no jury instruction, and I didn't say anything because I wanted to just kind of let it go and not object during closing, because there's a little bit of a thing where you don't object during closing a little bit, right? So, and I let it go, but then he said like 5 more times. I didn't beat his whole close. We did fine in the case, but as I look back, I would have liked to have, and I think I would have stood up and said, objection, Your Honor, counsel is reading or arguing the law to the jury, and it is not correct And I would ask the judge to, I would ask the court to not let him do that. And then what a judge is going to do is say the jury will be guided by the, the jury will be guided by the court's instructions, blah, 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 blah. So it is a judgment call. Maybe you let him, I don't know. So there you go.
So a next one, this is the one that is so tempting for plaintiff lawyers, the golden rule arguments or personalization. And basically the way it goes is that you cannot ask the jurors to place themselves in the place of the tort victim or the defendant. Those arguments are considered improper, but this is one definitely where you can go up to that line, and can be a bit of a gray area. And an example from the materials and from a case was that it's not a violation of the golden rule to argue who would sell their esophagus for $4 million. But it is improper to add at the end of that, I wouldn't sell mine. And so you just have to be careful about doing that. And I'm sure Gary probably has some good tips on putting the jury in the place of your plaintiff without doing so. So how do you do that, Gary, without committing error?
I just use generic things like people. People don't do this, or folks don't do this. I don't want to personalize it. I don't want to personalize, and you can't personalize it to the jury. You can't say, what would you do as a juror? And you don't want to use the golden rule either. So I just use the general people type of thing. I think that's all I got on that one, really.
Yeah.
You really want to stay, you've got to stay away from that. It's hard not to sometimes about where that line is, because it's effective, right? The golden rule argument, it's an effective argument. So there you go. That's what I would do.
Then Gary touched on this a little briefly, but referencing dismissed or abandoned pleadings, that's improper because they're irrelevant. They're no longer part of the case. This could come in the context of the plaintiff amended their petition or complaint, or they pled things alternatively, or the defendant answered one way and then filed an amended answer as the evidence came to light. And so abandoned pleadings are not evidence in the case, and so it's improper to reference those.
Hey, can I go back to my golden rule thing? Here's the other thing, though, is this is, I don't want some of these defense lawyers to hear my trick. So maybe, but you know what, why not? And let's answer. Dave Simpkins posted a question here. Speaking of defense lawyers, I want to address here in a minute. But here's the other thing, though, that I do is, does everybody know what the state motto is of the state of Missouri? That's sitting there above the judge in every courtroom. It is Salus Populi Suprema Lex Esto. I do not have that memorized, but what that means is let the welfare of the people be the supreme law. And you could say, and this kind of goes to golden rule, it kind of goes to sending a message. You can't say send a message to the defendant, but what you can do is you can say, look, we're here. We want you, the jury, to decide this because you are our community, and our community needs to decide this issue, and you need to speak to this. And that motto under here says, let the welfare of the people be the supreme law. And you are empowered to do that today when you follow the law and the judge's instructions and apply the facts to that. And I think that cuts to a couple issues for what it's worth. And then let me ask, because Dave posts let me ask you this, Genevieve. Dave says, Simpkins says, always ask for a mistrial. The court, and I lost the chat, but it was basically the judge is never going to grant it, and you don't preserve your error unless you do ask for a mistrial. What do you think about that?
That's absolutely true about preserving the error. You have to object if you're going to preserve that error. I have had judges grant mistrials before, even as And, you know, I think sometimes they're more inclined to grant them earlier on in the case. So I've had mistrials during jury selection where lines were crossed about things that were in motions in limine. So I think, you know, it's probably a proper practice to object and preserve that error. But again, to your point, also, a lot of times you don't object a whole lot in people's closings. So it really is just a balance, and you need to think quick, and you need, if you're going to object, you have to do it right away.
Hey, Dave, you have something to add on that?
I do actually, Gary. Three things. First of all, I'm not doing defense work, I'm doing plaintiff's work. But more importantly, whenever you make that argument, you do two things. One, you scare the hell out of the opposing attorney, and you get the judge to take it seriously. So whatever argument your opponent is making that's illegal, they immediately stop and get way away from it because they're scared that you just move for a mistrial and that they're going to violate the judge's order and the case will end. But no judge is ever going to grant a mistrial during closing. You've worked for 2, 3, 4 days, and it's all argument anyway. And I've never seen I've never even heard of an example of a mistrial being granted during closing argument. I've seen it during opening statement, but never closing.
I didn't mean to insult you by calling you a defense lawyer, but I've had cases against you, so sorry. Just kidding. Great, good points, good points. It's less likely in close. You do have to preserve your error. Go ahead, Jen.
So you touched on this one, the send a message arguments. No matter what you do, never use those 3 words. Never say send a message. And again, it's kind of like, how can you say send a message without saying send a message? And there are ways to do that, but stay away from those 3 words when there are no punitive damages involved in the case. It's, you know, to Gary's point, it's improper because it's effective, and it's, you know, uniformly not allowed to say that.
So how would you say send a message without saying send a message, Genevieve?
I guess, you know, you try to talk about the importance of the outcome of the case on your client, and, you know, what your client has been through, and like the case is important to them, and, you know, you can talk about justice and everything, but it shouldn't be as much about punishing the other side or something generally on principle. I think if it's a little bit more personal, sometimes that can help.
Yeah, you know, the other thing you do in these cases is, you know, the defendant, they didn't do any, I do this all the time. The defendant, they denied they did anything wrong. They didn't do anything wrong. They're going to drive the same way from this courthouse when this trial is done, and you're going to be driving right next to them. So I guess they can go out and they can tailgate people, and they can run right up on people, and they can crash in them, because that's their okay way to drive. And you ask them, this is something you build up in the evidence at trial. You say, so, you know, let's say you get that defendant who they never did anything wrong. And so you get up and you say, you double down on that with them. You say, you never did anything wrong. You didn't do anything wrong. You drove like this for 20 years. You're going to drive like this tomorrow. There's no way, absent a jury verdict in this case, it's going to change you in one way because you never did anything wrong. Is that right? Yeah. And you're polarizing the case a little bit. You're letting the jury know that they're there for a reason. They are there for a reason, because they're sitting there for 3 days, and they're like, because you know, you don't want that defendant to come in and admit liability in opening statement, right? And then they're sitting there for 3 days and they're saying this is just about money. Why this plaintiff is reading? No, you do send a message and a driver. The other thing you do with a corporate defendant or institutional defendant is this is where I spend my time in these cases is, did you investigate this? Did you change anything? I mean, you get a defendant who never investigated, whitewashed it, didn't do anything, didn't change anything, and kind of doesn't care. That's your case, you know. So you didn't investigate this, you didn't change any policies, you never disciplined this guy, you never even wrote him up, you didn't do anything. He's out driving. You say he didn't do anything wrong, right? So you never changed anything, you never did anything, blah, 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 and you're going to keep doing it right way. You're not saying send a message. But what you're telling the jury is, and appropriately, is that if they don't find this action negligent under these facts, this defendant is going to continue to be dangerous. And then the other thing you do is you talk about in the case about it injured your client on that day, but who else is it going to injure? You're crossing the defendant. I mean, isn't there a school bus stop right down the street for this? Don't people in wheelchairs cross this same intersection? How many miles a year do your truck drivers drive where they're around it? How doesn't your truck weigh 80,000 pounds and aren't all the other cars 6,000? So I guess the point is, and I already belabored it, right? But sorry, Genevieve, is make the send. If you're worried about how to send a message and close, you need to think about that way before and let that permeate through the whole case so the jury knows why they're there.
So then another one that's improper are pleas of poverty, or obviously discussing the presence or absence of insurance. And speaking of Art Clark, I had this happen to me in a closing where it was a car accident case, and he said, defendant is a hardworking janitor. He works really hard for his money, to support his family. And he's losing sleep at night thinking about what he's going to do if there's a big judgment against him. And that's completely improper. And that was, him trying to, I guess, not explicitly toe the line, but I mean, that's improper. And then Gary and I have talked about this. That was one of my first trials. What can you do about that? So further down in the materials, fair retorts are allowed. And basically,
12, I think.
Yeah. So
you can't do. Go ahead, Jen.
Yeah. So you can respond if they're doing something improper, you can respond, similarly, even if it might be a little improper, we think. So if, defense counsel is trying to imply that the defendant is going to have to pay a verdict from his own money, a fair retort would be, defendant's not going to have to pay this verdict. Where if I just did that on my own, then, prior to him saying anything, that would be probably also error. But since
can I say they have insurance?
I don't know. I don't think so.
Well, it's a line you're running. You're running the risk to put error in it. But that, if they say that they're personally liable, I think it depends on how your case is going, right? I mean, you may want to. I think you want to say they got Allstate insurance. That's totally not true. And then you offer 2.07 or 3405 jury instructions that say insurance. The topic of insurance has been injected into this case. The jury is not to consider that in coming up with its verdict. But before I did that, I'd want to know what the cases say on that.
Right.
Dave, you got something?
Yeah, I was going to say, but before I did that, I would, after the opposing attorney makes the improper argument, I would go to the judge before I started my argument and said, look, judge, counsel injected this.
That's exactly what I was going to say. Go ahead.
Do you hear me? I would say the opposing counsel argued this improperly. Now I'm going to say this because she opened the door and make sure the judge is okay with it before I made that argument. Because injecting insurance could, to me, give you a mistrial even in closing.
I think it could too. It's a hard thing. It's a hard thing. Maybe the better course is to not do that. Move for a mistrial. Tell them and say this that they're not going to pay this verdict, and they're not going to lose a dime. And then you preserved your error. Wait to see what the jury does on that. So that may be another way to do it. Can you say, Genevieve, since we're talking about good old Art Clark, can you criticize the plaintiff? And this is all about greedy plaintiffs' lawyers, and they're just trying to get money, because I think he said that in every case I've ever tried against him.
No, you are not supposed to, talk about bias or inflammatory, prejudicial type things. And That's number 9, remarks tending to create bias or prejudice. So the example they gave in one of the cases was that it was error to reference St. Louis lawyers. I don't know why that would be error, because I think we're the best, but it was probably the tone and probably weren't St. Louis.
Unless you're over in Illinois, right? Are you a
Right,
St. Louis
exactly.
lawyer? Go ahead, sorry.
Right. So things like that, or, ambulance chasers, frivolous lawsuits, they're just, sort of inflammatory and there to arouse prejudice. And so those types of things aren't proper, though they often happen.
Genevieve, can you tell us a little bit about motions in limine and how we guard against these things when we're walking into this?
Right. So a lot of these things that we've gone through today are just automatic motions in limine, or things that we file ahead of time and get rulings on. And so, even if you don't need a motion in limine, if you can address them ahead of time and get a ruling, that still helps. It explicitly has, that force and effect of there being an order. So then also there may be case specific things that were the topics of motions in limine that, in other cases would be fine. But in your case, if it's a motion in limine and the evidence was excluded and it's brought up in closing, that could also be error.
Hey, Genevieve, I'm just looking, we're at 12:51 now. Do you want to, anything you haven't touched or any closing points you wanted to make? Great job.
Yeah, my favorite one actually is 10, using graphic aids, what and what not to do. When I was in law school at WashU, our trial adjunct was Judge Wilkerson from Southern District of Illinois. And he always said the person with the most demonstratives wins, because juries can be very visual. And so I love graphic aids and charts and diagrams, but you have to be careful how you use them. Similar to what David Simpkins said, it's good practice before breaking it out to run it by opposing counsel or the judge and just say, hey, I'm planning on using this. Is there any objection to that? But they can be very, very effective, but you cannot use a chart or graphic aid and treat it as though it's evidence when those facts or the evidence are not actually in the case, if that makes sense. But you can blow up, jury instructions or quotes from or admissions from a deposition transcript. You want to keep the jury's attention, but again, you can't insert facts that aren't in the record, or, you still just have to be a little bit careful.
Yeah, have your key parts of your instructions ready to go. It doesn't have to be the exact copy of the judge. You can have that up. Have your damages part and your calculating damages big. Mark them with exhibit stickers. Then the jury doesn't know what they can see and what they can't see. And then you want that first question to be from the jury to be, can you send me back your chart of damages? And then always, isn't it true that you always leave all your demonstratives up on your easel in front of the jury and sit down and let the defense lawyer have to put them away?
Absolutely. Yes.
That's a little trick. Leave them up, but they may say take them down and stuff. But I've sat through closing where I kind of move it aside, and then my damages are up the whole time while the defense lawyer is calling, and while the defense lawyer is talking. Use pictures. Use the X-ray of all the hardware in your client's spine or in their femur or whatever it is. I mean, a picture's worth 1,000 words, and we've got to remember that. 80% of what people hear is what they see. They hear 20%, but it's all visual. This is visual. So that's a great point, Genevieve.
Yeah. I don't know if anyone else has any horror stories of things that have happened to them in closing, or, things that they've learned the hard way that they'd want to share. And I guess, another thing too, you have to be careful about insulting opposing counsel. You're not really supposed to express contempt for them, during the arguments. So you have to be careful about that too.
Unless it's justified, right? Just kidding. All right, everybody. Great job, Genevieve. Thank you very much. Very effective. All right, folks, we're gonna take 5 more minutes and then we're gonna start with ethics. So we're gonna go off for a couple minutes, use restrooms, get snacks, whatever you want. We'll see you all in just a minute. Thanks, Jen.